You're saying this was not an emergent situation, so why were you traveling 60 to 65 miles per hour in a 30-mile-per-hour zone?
This isn't a felony case, but it's one of the most important depositions I've ever reviewed. It shows what happens when an officer's word is his bond, until the body cam turns on. Officer Jonathan Chang sat across from attorney Richard Hyde, phone records already subpoenaed, dash cam footage already logged as an exhibit, and gave his answer anyway. He was speeding toward a stolen vehicle report. No sirens, no lights, not an emergency by his own admission. Then Hyde asked the question that mattered: if this wasn't an emergency, why were you driving 2 times the posted speed limit? Chang paused, agreed Hyde was right, and kept talking anyway, digging the hole deeper with every sentence.
And it's not an emergency situation, certainly, because you didn't have your sirens going at the time of the impact, did you?
That is correct.
You didn't have your light bar activated, did you?
That is correct.
So it wasn't an emergency situation. You're driving 2 times the posted speed limit, and you're...
That single exchange, 3 minutes into a sworn deposition, was the moment his legal defense started to collapse. By the end of this video, you'll understand exactly how a routine traffic collision becomes an open and shut case of negligence under Texas law, and why wearing a badge offers zero legal protection once an officer starts explaining himself under oath. On July 21, 2023, in Dallas, Texas, Dallas Police Department Officer Jonathan Chang, driving a marked squad car, rear-ended a civilian vehicle on 2nd Avenue, a designated 30 MEPA zone. The collision occurred while Chang was responding to a non-emergency report of a stolen vehicle. The resulting civil litigation produced a formal deposition, where plaintiff's attorney Richard Hyde questioned Chang under oath on behalf of the plaintiff, Sani Gam, regarding the events of that night. Sani Gam was an ordinary driver on an ordinary afternoon, executing a lawful left turn with his brake lights illuminated and his signal engaged. In an instant, that routine errand became a lawsuit, a mounting stack of medical questions, missed work, and a legal fight that would eventually require a settlement exceeding 6 figures to resolve. That number alone should tell you this wasn't a minor fender bender argued over insurance paperwork. It was a case built almost entirely on one officer's own contradictions, captured on video and repeated under oath. Chang's version of events, at first, sounded almost sympathetic. He was chasing down a report of a stolen vehicle, working his job, doing what officers do every day. He said he was traveling 60 to 65 miles per hour because that's what the traffic flow around him was doing. He said the phone in his hand was open to Zello, an official department app used for team communication, not personal use. He said the other driver braked suddenly and without warning, leaving him no time to react. Taken entirely at face value, this reads like an unfortunate accident during honest, well-intentioned police work. The kind of account a jury might extend real sympathy toward, especially from a demographic that generally wants to give officers the benefit of the doubt. Most people watching this deposition would stop right there and assume the case was essentially a wash, a he said, she said dispute where an officer's word carries the usual institutional weight. What they'd miss is one detail buried early in Chang's own testimony, delivered almost as an aside. He admitted, unprompted and without being pushed, that he wasn't running his lights or his sirens. No flashing bar. No audible signal. That single admission, made casually in the first few minutes, would end up doing more structural damage to his defense than anything Hyde asked him afterward. Under Texas Transportation Code Sections 546.1 through 460.05, an officer is permitted to exceed the posted speed limit only when responding to a genuine emergency call or engaged in an active pursuit of a suspected law violator, and even then, only while using audible or visual signals, sirens, lights, or both, to legally invoke that exemption. Critically, the statute does not stop there. Even during a lawful emergency response, an officer is never relieved of the ongoing duty to operate the vehicle with appropriate regard for the safety of everyone else on the road. Chang had none of the qualifying conditions. No lights, no sirens, no declared pursuit.
You went through some training to be a police officer.
Yes, sir.
If you don't have your sirens going, are you allowed to drive 2 times the speed limit?
No, sir.
Okay, so you did that wrong.
Yes, sir.
Similar question. If you don't have your light bars activated, are you allowed to drive 2 times the legal speed limit?
No, sir.
So you did that wrong, right?
That is correct, sir.
And
Which raises the exact question his own testimony was about to answer for him, whether he intended to or not. If none of the recognized emergency exceptions applied to him that night, what legal shield was left standing between his conduct and a straightforward traffic violation? Hyde built his cross examination methodically, 1 brick at a time, and the pace accelerated as the contradictions piled up. He got Chang to confirm on the record that he had no sirens running. He got him to confirm no lights.
showing on that screen what I've marked as plaintiff's deposition exhibit number 8. Now, this is a clip from much bigger footage that was produced in the litigation. Rather than go through 30 minutes of dash cam and body cam footage, I've clipped it out. And I'll represent to you that what we're seeing here is the first time I'm seeing your cell phone, if not the only time I see your cell phone on that body cam footage. This is your body cam. Earlier you said, or earlier you testified that the last thing you were doing on your phone was using this Zello app to communicate with the rest of your Dallas PD team.
He got him to confirm that the device in his hand at the moment of impact wasn't strictly a work tool. Body cam footage showed the phone waking up to a personal text message thread, complete with photo attachments and a string of laughing emojis, the very last thing visible when Chang picked the device up.
And the first thing we see when you open that phone is what appears to be a text message or text message conversation. Do I have that accurate?
That is correct.
So the last thing that you were doing on your phone was this text message.
And no,
You can answer.
why it's on right there, I have no idea. You know, you have a phone. Do you have an iPhone? Do you have an iPhone? There's all of these different apps and all these different things that you use, and they open up. And there's times when you open, not when you unlock it, when you grab your phone by accident, you touch it with your fat finger, and they all open up, and they can either move from right to left, and they can change depending on what it is.
I know how an iPhone works, and presumably it's a popular phone. A jury is going to know how an iPhone works. And
Yes.
you're disagreeing with me that when you open your iPhone, it opens to, you're saying it does not open up to the last app you use.
Chang first insisted this was purely accidental, a phone that had simply switched apps on its own while it slid across the seat. Hyde didn't argue. He simply played the dash cam footage frame by frame, showing Gam's brake lights fully illuminated for 13 uninterrupted seconds before impact. While Chang had told the responding officers on scene, repeatedly and specifically, the Gam had slammed on his brakes without warning. The video showed a vehicle slowing to roughly 5 miles per hour to execute a lawful turn, signal and brake lights active the entire time. It is what it is, Chang finally said, staring at footage that directly contradicted his own prior statements.
The jury in this case under oath that my client abruptly slammed, or I'm sorry, the driver of my client's vehicle abruptly slammed on his brakes.
From my perspective, yes.
From your perspective, what does that mean? It is what it is, right?
That is not what it is. That night, that afternoon actually, while I was driving, I saw the car, while I was driving, it suddenly stopped.
Well, did it suddenly stop, or from your perspective, it suddenly stopped?
My perspective, sir.
Okay, I'm asking about reality. realistically, looking at everything, you're a cop, you investigate. Realistically, did he slam on his brakes or abruptly stop?
From looking at the video, it seems like he was stopping and he was turning.
His brake lights were illuminated in that video we just saw, were they not?
Yes.
Okay, and you told
And
the
he was
officers that he did not have any brake lights illuminated.
I didn't see them, sir. Until, like I said, I haven't seen any videos. I haven't seen anything till today.
That sentence is the moment the entire deposition turns from defense to damage control.
Street lights, like the one we see here, and there's several of them, they don't have wheels, do they? Street lights don't have wheels. They're not moving. They're fixed in place, right? And the only thing that's moving is you. Everything else is stationary in this video, right? Do I have that right?
No. Like I said, yes, he's slowing down. And as you can see, the other car on the right wasn't stationary. She keeps on moving. Okay. But once again, like I said, and I get where you're going with this. You're doing a great job. That is your job. Like I said, take full responsibility. I was going over the speed limit. I caused an accident.
Here is what that admission actually means outside the four walls of a courtroom. Once an officer confirms, under oath, that he violated a statute enacted specifically for public safety, speeding, operating a phone while driving, drifting out of a marked lane, Texas law applies a doctrine called negligence per se, meaning the violation itself establishes fault automatically, without requiring a jury to weigh intent, reasonableness, or context at all.
That's all.
On Plaintiff's Exhibit Number 1, Officer Chang stated multiple times to the investigating officers that he was wearing his seatbelt at the time of the collision. However, during his deposition, the officer admitted under oath that his on-scene statements were untrue. This admitted falsehood constitutes a direct violation of Chapter 12A, Section 12A-1B6 of the Dallas City Code of Ethics, which mandates absolute truthfulness from all city employees. It also directly breaches the Dallas Police Department Code of Conduct regarding honesty, which strictly demands that personnel maintain the highest standards of integrity during professional investigations. Under Texas Transportation Code, Section 545.413, a driver commits a legal offense if they operate a vehicle equipped with safety belts and fail to be properly secured by one. Because this statutory provision contains no exemptions, immunities, or special privileges for on-duty law enforcement personnel, the officer's failure to buckle up constitutes an explicit violation of state traffic law. Furthermore, under Texas Transportation Code Section 521.025, a person who drives a motor vehicle without their physical driver's license in their immediate possession is committing a misdemeanor offense. The statute mandates that a licensed operator must carry their physical credentials while driving and display them upon the demand of an investigating peace officer. Rather than being issued a standard citation or undergoing routine verification, body cam footage reveals that the officer bypassed standard on-scene verification by
Chang wasn't merely embarrassed on the record. He handed the plaintiff's legal team a direct, statutory shortcut to liability that no amount of sympathetic framing could undo. A properly prepared officer never tells investigators on scene that a driver slammed on his brakes without first reviewing the available footage, because that statement, once contradicted, poisons every account that follows it.
Why is it so obvious that you weren't wearing your seatbelt?
From what he showed me.
What?
From what he showed me?
What he showed you?
Yes. He was asking me, so when there's a collision, the seatbelt locks. So he's pulling it and he's showing me. So I started thinking, I was wearing it. Why did it lock? So that's what I'm telling you. I went back. I started thinking about everything. How everything went on. Like, okay, I wasn't wearing it because I picked up my phone.
Yeah, but we can watch the video again if you'd like. But when you said that, you were sitting right next to the driver's side door. He was yanking on the seatbelt, showing it locked up, and you said, yes, I was wearing my seatbelt.
Because I was adamant. I was sure that I was wearing it. That was my answer.
Despite seeing it locked up like that.
Exactly.
A department that trains officers on proper Zello protocol should also train them, explicitly and repeatedly, on the narrow legal definition of an emergency response, because the gap between those two understandings is exactly what turned offender Bender into a 6-figure settlement. And here's a confession worth making honestly. Most people assume that once an officer is behind the wheel responding to any call involving a crime, normal traffic rules simply bend around him. That is not what Texas law actually requires, and Chang's own deposition proves it in real time. There was no trial here, no jury verdict, no judge delivering a ruling from the bench. The case resolved through a negotiated settlement exceeding 6 figures before it ever reached that stage. And no public record confirms whether Chang faced any internal disciplinary consequence at all. That absence of accountability is its own kind of ruling. It tells you that the legal system extracted a financial cost from the city. But the officer whose testimony collapsed under basic cross-examination walked away with no confirmed consequence attached to his name. And that gap between institutional cost and individual accountability is precisely where this audience's frustration lies. This case matters to anyone who has ever assumed a badge settles an argument on the road before the facts get a chance to. The law doesn't actually work that way. An officer's authority ends exactly where the statute does, not where his confidence does. And sworn testimony can unravel a uniform's credibility faster than any outside accusation ever could. Next time, we're examining what happens when a criminal defendant's own body cam footage contradicts a police officer's sworn courtroom testimony, and whether that kind of contradiction is enough on its own to collapse a prosecution entirely. Was what happened to Sani Gam the result of one officer's individual failure of judgment in a stressful moment? Or is it evidence of a broader culture that trains officers to explain away their own conduct after the fact with little real consequence when the explanation falls apart? And if it's the latter, what would meaningful accountability actually look like?